We have very good friends.
I
Yes.
highest respect
Absolutely. I share that.
By slip of tongue, if I have said something.
No, the court also shares that.
Refer to. May I request your lordship to kindly tend to, let it was a 3 judges bench. 2 judges would concur and the 3rd judge would differ. He is placing reliance on the
Oh, the dissenting judgment? All right.
But while quoting, my lord, the concurrent judgment in the statement of objections, you please grant it. May I request your lordship first for a second?
Page?
My lord, before I take your lordship to this judgment, my lord, let me submit to your lordship one thing. The conviction is for an offence under section 379 and 420. That is number 1. Number 2, it is not the case of the prosecution also that either by the user or by the misuser of the office I was holding as a legislator, I committed this offence. No, independently, my lord, as a businessman, I have committed the offence. Had it been by user or misuser, just like a public servant, my lord,
Yes.
supposing a conviction is there, he may
So
go.
it is not misuse of the office.
Yes, office. That is probably my appeal to your lordship is kindly keep that in mind. Then let us go into it. Number 1. Number 2, my lord, under the RP Act, my lord, after the Supreme Court struck down 8.4, my lord, section 8.4. Now what remained under the statute is 8.3. Have a look at 8.3, my lord, for a second.
Representation people.
RP Act. ಇದೇನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ 7 or 13 ವರ್ಷದ ಏನು ಮಾಡೋ ಹಂಗೆ ಇಲ್ಲ. Not 6 years. 13 years. Have a look at section 8.3. Supposing the appeal is dismissed, I would be required to undergo the sentence as imposed by the trial court. A person convicted of any offence and sentenced to imprisonment for not less than 2 years other than any offence referred to in subsection 1 or subsection 2 shall be disqualified from the date of such conviction and shall continue to be disqualified.
So 8.3.
A period of 6 years.
8.3.
I'm sorry, 8.3.
1 minute.
I'm sorry.
Subsection 3 of section 8.
Although a person convicted of an offence and sentenced to imprisonment for not less than 2 years other than any offence referred to in subsection 1 or subsection 2 shall be disqualified from the date of such conviction and shall continue to be disqualified for a further period of 6 years. Kindly note this, mark this, since his release.
The Representation of People Act.
RP Act. Nanda, shall I pass on my act?
Really, 8.3 is consolidation of subsection 1 and section 3.
In fact, that has been referred to in this judgment also.
51, sorry. Yes.
After his release, 6 years after his release, first he has to undergo the sentence as imposed.
No, it is 1951. I am seeing 50. Yes. Yes, sir. Now I get it. Yes.
But at this point of time, we are certainly not on the merits of the matter. I'm sure your lordship would certainly agree with me.
Yes.
But now let me invite my lord's kind attention to Afzal Ansari.
Yes.
My honourable friend has referred to in his statement of objections as well. I would like to first draw my lord's kind attention to paragraph 9. Well, what were the submissions which came to be made in one paragraph that has been quoted in their lordships? Paragraph 9 means internal page 201 of the judgment. Dr. Abhishek so Lawrence Senior Counsel for the appellant argued that the High Court erred in not granting the suspension of the conviction, especially in the light of the fact that disqualification from membership of Parliament leads to irreversible consequences such as, number 1, the loss of the next 6 months as a member of the Parliament in the Lok Sabha. Number 2, disqualification from contesting elections for a total period of 10 years. Number 3, he further contended that such a disqualification would not only result in the appellant losing his right to represent his constituency, but would also rob his constituency of its representation before the Parliament. The Lawrence Solicitor General also highlighted the infirmities in the impugned order. The High Court, in denying stay of conviction along with the material contradictions in the prosecution case against the appellant. May I request your lordship to kindly turn to paragraph 12 now for a second.
Yes.
In our considered opinion, the questions that fall for deliberation are set out as follows. What are the parameters in this case, even in the earlier two writ petitions which came to be filed by the certain pro bono publico in the form of public interest litigation before the Supreme Court, they would say that there is no provision under the provisions of the Code of Criminal Procedure for staying the conviction It is only sentence that could be stayed and bail could be granted. In our considered opinion, what are the parameters to be considered for the suspension of conviction under section 389(1) CRPC? Whether the appellant has made out a prima facie case for the suspension of conviction under section 389(1) of the CRPC. Kindly go to para 14. At the outset, it is imperative to delineate the essential parameters that must be meticulously examined to determine whether a case can be made out for suspension of conviction under section 389(1) CRPC. Section 389(1) enjoins upon the appellate court the power to issue an order for suspension of a sentence or an order of conviction during the pendency of an appeal. It may thus paramount importance to scrutinize the precise language of section 389(1) of CRPC, which is articulated as follows. Well, I shall skip, my lord. Their lordships would quote to section 308. Ultimately, they would say, my lord, not only under section 389, but also under section 489, the court has a jurisdiction, my lord, to order the stay of conviction. May I request your lordship to kindly go to paragraph 15 to 27 now.
15 to 27.
15 to 27. 28 guidelines. What needs to be done? It becomes manifestly evident from the plain language of the provision that the appellate court is unambiguously vested with the power to suspend implementation of the sentence or the order of conviction under appeal and grant bail to the incarcerated convict, for which it is imperative to assign the reasons in writing. The court has undertaken a comprehensive examination of this issue on multiple occasions, laying down the broad parameters to be apprised for the suspension of the conviction under section 389(1) CRPC. There is no gainsaying that in order to suspend the conviction of an individual, the primary factors that are to be looked into would be the peculiar facts and circumstances of that specific case, where the failure to stay a conviction would lead to injustice or irreversible consequences. The very notion of irreversible consequences is centered on factors including the individual's criminal antecedents, the gravity of the offense, and its wider social impact, with simultaneously considering the facts and circumstances of the case. Well, I shall skip this paragraph 16, 17, and 18. Now, my lord, kindly go to 21 straight away. Well, their lordships would, in those preceding paragraphs, would deal with section 389(1) and all that. Kindly go to paragraph 21. We say no, so primarily for the reason that the potential ramifications of declining to suspend such a conviction are multifaceted. On the one hand, it would deprive the appellant's constituency. My lord may kindly mark this. On the one hand, the appellant would deprive the appellant's constituency of its legitimate representation in the legislature, since a by-election may not be held given the remainder tenure of the current Lok Sabha. Well, that was the facts of that case. Conversely, it would also impede the appellant's ability to represent his constituency based on the allegations, the veracity whereof is to be scrutinized on a reappraisal of the entire evidence in the first criminal appeal pending before the High Court. This would potentially lead to the de facto incarceration of the appellant for a period of 4 years under the UP Gangsters Act and an additional 6-year disqualification period, even if he is eventually acquitted, which would effectively disqualify him from contesting the elections for a period of 10 years. But this is how I submitted to your lordship. After he is released means after this completion of the sentence, that is 7 years plus 6 years, 13 years, he can't even contest the election. It is essential to emphasize that while the appellant did not enumerate any material facts, but the court can so much to take cognizance of those. That is what the Supreme Court would say. Regarding irreversible consequences in his application, filed before the High Court seeking the suspension of conviction, this principle can be traced to the statutory provisions outlined in Section 8 of the RPA. The High Court or this court, however, while exercising their appellate jurisdiction, are well empowered to take judicial notice of these consequences. Additionally, the respondent also does not contest the fact that if the conviction is not stayed, the appellant would not only face disqualification as a member of the 18th Lok Sabha, but would also incur disqualification to participate in future elections for parliamentary or state legislative seats. Taking into consideration the consistent legal position adopted in this regard, the severity of these outcomes underscores the urgency and gravity of the matter on hand. Now, may I request your lordship to kindly go to, ultimately this is what their lordships would say. paragraph 27 and 28. It is therefore imperative to weigh the competing interests presented by both the appellant and the state. This case pertains to the appellant's disqualification as a member of the Lok Sabha under section 8(3) of the RPA, which disentitles a person who has been convicted and sentenced for a period exceeding 2 years from holding office or contesting the elections. The state's pursuit of a conviction under section 3(1), etc., that we are not concerned. Conclusion and directions, paragraph 28. This is what my learned friend would quote in his statement of objections. We thus deem it appropriate to partially allow this appeal and suspend the conviction awarded to the appellant in special sessions trial number so and so, subject to the following conditions and clarifications and directions. The Ghazipur parliamentary constituency shall not be notified for the by-election in terms of section 151 of the RPA till the decision of the appellant's criminal appeal by the High Court. The appellant shall, however, not be entitled to participate in the proceedings of the House. He shall also not have the right to cast his vote in the House or to draw any perks or monetary benefits. The continuance of MP law, welfare schemes in the Ghazipur parliamentary constituency without the appellant being associated for the release grants for such schemes is not an irrevocable consequence, as all such schemes can be given effect to even in the absence of the local parliamentary representative. The appellant shall not be disqualified to contest the future elections during the pendency of his criminal appeal before the High Court, and if he is elected, such election will be subject to the outcome of the first criminal appeal.
28.2.
28.2 minutes. The appellant shall, however, not be entitled to participate in the proceedings in the House. He shall also not have the right to cast his vote in the House. Quite right. That should be one of the conditions which needs to be imposed in the event.
The reason that you moved it for suspension of conviction,
Allah.
that he has to participate in the House.
Election ಮಾಡ್ಬಿಡ್ತಾರಲ್ಲ
ಅದು ಗೊತ್ತಾಯ್ತು.
ಅಲ್ವೇ ಎಲೆಕ್ಷನ್ ಮಾಡ್ಬಿಟ್ರೆ ಐಲು ಎಷ್ಟು 13 ವರ್ಷ. If my lord is persuaded to accept my submissions, and if my lord were to ultimately say, yes, you are entitled for the stay of the order of or the judgment of conviction, can you impose the very same conditions? I am not saying anything more or less.
The dissenting view of Justice Dipankar Datta is otherwise.
Yes, that is. My lord, I have several other judgments of the Supreme Court commencing from Sidhu's case also. That's what they. My lord, the latest judgment of the Supreme Court is following Afzal's case. This is what the Supreme Court would say. My lord, it is an unreported judgment and order of the Supreme Court in Ponmudi's case, that is Tamil Nadu's minister. Their lordships would follow Afzal's case and would say, paragraph 3, my lords.
Bail matter.
Yes.
Afzal Ansari suspension of
Yes, my lord.
conviction.
Therefore, in the facts of the case and in view of the law laid down by this court in etc., suspension of sentence. Well, I think I need not trouble your lordship with other judgments. Number of judgments are there. In the point. Same proposition.
On the compilation, yes, Sunil Kumar.
Lok Prahari and other. No. What my learned friend is telling me is, my lord, public interest litigation in the form of a writ petition came to be filed that there is no.
No, let us not go back into the root of this problem.
Please.
But what is the present problem? We'll address it.
My appeal to your lordship and request to your lordship is, if I am otherwise entitled for the benefit of an order of stay of conviction, impose the very same terms which the Supreme Court has said time and again in more than one judgment or order which came to be passed by the Supreme Court in a similar situation or similar circumstances.
Yes.
My submission was that not this judgment, which my learned senior friend referred to para 28.
You are right on that day to say, because application was moved that he would want to participate in the House proceedings. 28.2 relied on to say that yes, it is. Supreme Court has said he cannot. So that time is over now.
I continue to be a legislator.
Continue to be a
Para
legislator.
28.
Yes, I continue to be. I can go and sit there. That's all. Beyond that, my lord, I can't even open my lips there.
Allah, you shall not be entitled to participate in the proceedings of the House.
You can't even
You
enter.
can't even enter.
That is.
Not my submission was, when I read this para 28, my senior friend
really?
said it is a dissenting opinion. It is not correct.
No, it is not dissenting.
It is not dissenting.
It is the majority.
It is majority opinion. Kindly have a look at.
Dissenting is Justice Dipankar
Kindly have a
Datta,
look
which
at
dissenses from the
page 199. Madam.
Same thing is the order.
No. Kindly have a look at page 199 madam, of that. 199.
Anyway, whatever it may be, the fact remains.
Allah, fact remains.
There is
Allah.
majority judgment is the dissenting judgment.
he has not read it wrongly.
I
Dissenting.
have not read it wrongly.
It's a concurring opinion, majority view.
ಮೆಜಾರಿಟಿ ವ್ಯೂ not page.
And I remember 28.2 ನೇ ಓದಿದ್ದವರು.
ಅಷ್ಟೇ ನಾನು ಅಷ್ಟೇ ಓದಿದ್ದು ಅಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ನೋಡಿ. ಐ ಓನ್ಲಿ ಬ್ರಾಟ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ ನೋಟಿಸ್ ದಟ್ ದಿಸ್ ಇಸ್ ದ ಜಜ್ಮೆಂಟ್, ಲೇಟೆಸ್ಟ್ ಜಜ್ಮೆಂಟ್, ದಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫಾಲೋಡ್.
My lord, there, the dissenting, the Laren dissenting judge
then
would
even
say that I
the-
dissent, disagree.
No. The statement that fell is that he has quoted a dissenting opinion.
That is not correct.
No, he has
I
quoted
didn't say,
That's
No,
what-
my lord, I
that-
didn't
that-
say that
that's
he has
what he
quoted
said.
No, no,
That's what he said,
Prasanna,
sir. ಇಲ್ಲ
Prasanna.
ಸರ್ ಅದೇ ಹೇಳಿದ್ದು.
I didn't say that he has quoted dissenting judgment.
ಇಲ್ಲ ಅದನ್ನೇ ಹೇಳಿದ್ದಾವು ಸರ್ ರೆಕಾರ್ಡ್.
I'm sorry. What I said was, once a while he is very fair. He has
I'm
quoted the
always
judgment
fair.
which endures to my benefit. That is what I
I am
said.
always fair, not once.
That is what I said. In para 58, he has quoted it.
No,
As a defense counsel,
all of you are always fair.
but as a defense counsel,
Correct, correct.
but they are entitled to not say the crow is white. But not as a prosecutor, I am always and not. I have to assist the court and say, no, crow is black.
No, I
judgment
cannot.
not I cited.
I cannot
On the
say
other
black
day,
or white.
Your lordship will have to decide not based on the Milord law. Therefore,
Yes.
I brought to your lordship. These are not the condition that will
No,
have to be imposed. Not by consideration.
You have last time also read the majority view only,
Please, Milord.
and you have relied on that only. It's not the dissenting view.
Ask-
There must be some mistake while saying.
Yes,
All right.
I'm-
Yes. That's all.
I think same order, Milord.
Same order.
Same order.
Yes, ma'am.
We'll pass the same order.
Same order, my lord. Your lordship may pass the same order.
Yes.
Because I can't expect from your lordship my lord, an order which is contrary to or something different from what the
ಈಗ
Supreme Court has said.
ಯಾವ್ಯಾವ ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ಒಂದೇನಾ ಇದು
My lord,
ಒಂದೇ ಕೇಸಲ್ಲಿ ಯಾವ
So in 5 cases,
Milord,
not
ಹಾಕಿದ್ದೀವಿ.
five.
ಎಲ್ಲ all 5
There are
cases
6
they are
cases.
listed?
ಹೌದು.
In all, there are
Same.
6 cases. One is not listed.
FIR, one FIR.
ಒಂದ್ ನಿಮಿಷ ಸರ್ ವಿಲ್ ಟೇಕ್ ಒನ್ ಬೈ ಒನ್
15, 16, 17, 18, 19.
ಅಲ್ಲ,
Common
ಅದ್ರಲ್ಲಿ-
order Milord can be passed.
ಸೊ ಒಂದ್ ನಿಮಿಷ ಸರ್
15, 16, 17,
15
18.
16 17
and
18 19
ಎಲ್ಲದೂ ಹಾಕಿದ್ದೀವಿ.
ಎಲ್ಲದರಲ್ಲೂ ಯು ಆರ್ ವಾಟ್
I have made the appeal.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 2
Yes.
ಅಕ್ಯೂಸ್ ನಂಬರ್
Different
6
accused.
Not the accused number changes, special CC number
My lord,
changes.
rank is different.
the person is
That is
only
same.
one
Person
person
Rank
is
is
the same
different. Rank is
Yes.
different.
all right sir at same order will pass
Please,
Same.
please.
Deeply.
will have it uploaded day after tomorrow
Please.
or on Monday because Saturday ಇರೋದು. Yes.
ಆಮೇಲೆ ಇದು 6 ಇದೆ ಒಟ್ಟು. Today I don't know why only 5 cases have been listed.
ಇನ್ನೊಂದು ಬಂದಿಲ್ಲ ಅವು.
ಇನ್ನೊಂದು ಬಂದಿಲ್ಲ.
285 ಬಂದಿಲ್ಲ.
Same
Same person
person.
2085 ಅದು ಮಾಡಬಹುದು.
will get that posted madam
Yes.
ಅದು ಹಾಕ್ಸ್ಬಿಡಿ. Same
Same
order.
285 of 24.
Same.
Will pass a common order
Please.
referring to different accused in the sense number of the accused.
Number.
Same person, same Supreme Court.
Please.
Yes.
Deeply blessed.
The election notify ಮಾಡ್ಬಿಟ್ರೆ ಕಷ್ಟ ಅಂತ.
ಎಲ್ಲ ತೊಂದ್ರೆ ಇಲ್ಲ. Whatever not apex court says.
Yes.
Whatever apex
If I
court
have
says.
my lord, wrong listed.
ಅಲ್ಲ
I'm
ಸಾಹೇಬ್
sorry.
ಫ್ಲೋ ನಲ್ಲಿ ಏನು
We are good
So
friends.
whatever comes from
Of course,
it is
no.
not.
We are very good
I
friends.
Yes.
highest respect not in regards to
Absolutely.
my-
I hear that.
By slip of tongue, if I have said something.
No, the court also shares that. Yes.
Please, blessed.
Yes.